Hello everyone, myself Viren Sharma, faculty for GS Polity and Governance at Vajiram and Ravi. There are so many topics in the polity which are usually in the discussions and the current affairs, like defections in the political party, disqualification of MPs and MLAs, and these kind of topics are always important from prelims as well as mains point of view. So today we are going to discuss the topic Anti-Defection Law, which is one of the most important portion from the polity and governance. So let's begin this topic for a wider understanding and awareness, and we will include the contemporary issues and the challenges with respect to this topic. Let's begin with Anti-Defection Law. To understand this portion in a wider way, we will classify it into concept of defection, what are the grounds for disqualification, what are the exemptions from disqualification, limitations of this issue, what are the criticisms here, and the suggestion for reforms. This is how we can classify this entire portion, and out of them usually these kind of information are useful for the prelims related questions, and this portion is usually identified and useful from the mains point of view, on which we get a questions in the mains. So let's first begin with the concept part. What is this concept of defection and to whom it is applicable? When we talk about defection, so a person is a member of political party. From this political party, there are certain members who are working as MP, union government level. Some of them are working as MLAs, and some of them are working as even ward members in panchayats or urban local bodies. All of them are elected representatives from the different political party. Now this MP, if he shift from a party A and moves to another political party, this concept is considered by the term defection. And because of this, the strength of this political party declines in the parliament. And similarly, at a state level also, when the MLAs change their political party, the strength will decline at the state level and the government can reduce to the minority. And in this context, there has been a popular terminology is called Ayaram and Gayaram. So that thing has dominated the political system during 1960s, 70s, and finally in the 1980s, the law was made Anti-Defection Law. However, in the last 1 decade also, in various states, we have seen the sitting MLAs have changed the political party, resulted into collapse of the government. So in that context, this concept is useful. A member, sitting MP of a political party, leaving the party and joining another political party, and that process is called defection. To prevent this, the government has passed, with the help of Parliament, 52nd Constitutional Amendment Act 1985. And this amendment has introduced to the Constitution 10th schedule, and this 10th schedule has introduced Article 102 Clause 2 for Member of Parliament and 191 Clause 2 for Members of Legislative Assemblies. And anti-defection law is with the objective to prevent this defection and provide disqualification of the members. This is why these people, MP, MLA, they form a legislative party. And legislative party members are subject to the anti-defection law. There are other member X, Y, Z. They are not the office holder. They are neither MP nor they are MLA. They will not be covered by the anti-defection law. Even the panchayat member, municipality member, even they are also not covered by the anti-defection law. So as far as the concept is concerned, anti-defection law is applicable for the member who are member of parliament and who are member of legislative assembly. And when they changes their party, they will be subject to disqualification under anti-defection law. MPs will be disqualified under Article 102 Clause 2 and MLAs will be disqualified under Article 191 Clause 2. And these decisions will be taken by, in case of member of parliament, either speaker or chairman of Rajya Sabha, and in this case it is to be decided by speaker, and if there are MLCs then it will be taken by the chairman of State Legislative Council. That means presiding officer of the legislature will be having authority to take the decision about their disqualification. So the basic objective of this anti-defection law is to prevent political opportunism, to ensure political stability, and to reduce political corruption and change of the party in sake of minister or maybe the money which is offered for usually changing your political stand. Then what are the grounds for disqualification under the law? Let's understand it one by one. The grounds for disqualification. The major grounds which are included in this disqualification includes: 1, it is an independent MP or MLA or an MLC. So if any of them is going to join a political party, they will be subject to disqualification because they have promised to the people, we do not belong to political party, and now they are joining a political party. So that is like a distrust or deceit with the voter, and therefore this is a ground for disqualification. Similarly, if an MP, MLA of a political party and they goes and join another political party, they are also subject to disqualification. So here it is individual MP and individual MLA. Similarly, if less than 2/3 of MP or MLAs, they are leaving party and forming a new group, in that case they are also going to be disqualified because it is less than 2/3. And this kind of situation has happened in the state of Madhya Pradesh, where 20 MLAs from ruling party in 2020, they left their ruling party and they joined the opposition party. Because of that, even the government of the state got collapsed, and thereafter the opposition party got the strength and they have been able to form the government. And this is what is the problem with defection, that it creates a political instability within the country at state or even at central government level. Then another ground is if a member violates whip. If a member violates the whip, and then what he do? Either he abstain from voting or he vote against the whip. In both of these cases, the concept of anti-defection law will be applicable, and these MPs or MLAs from the party can be disqualified. In fact, in 2024, this happened in one of the state of Himachal Pradesh, where 6 MLAs in the Rajya Sabha election voted against their own party candidate and they voted in favor of opposition party candidate. And because of this thing, the party has not taken a decision, but it is a ground for disqualification under the anti-defection law. So ruling party member are voting in favor of opposition party member. This is generally called cross voting, and political parties issues whip to their member in such cases and can take action for the disqualification. And apart from this, if a nominated member, nominated MP or nominated MLC, in Rajya Sabha 12 members are nominated, and in the MLC also 1/6 members are nominated. If these nominated members join a political party after 6 months, then in those circumstances, these are going to be disqualified. These all are the major grounds for disqualification existing under the anti-defection law. Let us understand there are few exemptions where a member will not be disqualified. These are called proviso or exemptions from anti-defection law. And there are usually 3 conditions exist under this proviso. 1, if a nominated MP or MLC joins political party within 6 months, joins political party within 6 months, they are not going to be disqualified. After 6 months they join, that is subject to disqualification. Then another condition is if not less than 2/3 MPs, MLAs or MLCs, they leave their political party and either they create a new group or they merge with other party. In both of those cases, there will be no disqualification going to happen. And it has happened in the states recently with the state of Maharashtra, 2022. There was a split of Shiv Sena plus there was also a split of NCP. And in these cases, the larger number of members have decided to go out and that created a political crisis. The problem is these things will be covered as an exemption because majority of the members are going. In fact, one case happened in state of Rajasthan 2018 where the BSP MLAs, 6 MLAs were there in the state and they all merged with the INC. 100% merger has taken place and they get exempted from the provision of not less than 2/3. And that's why these kind of loopholes are sometimes manipulated within the law. Then comes a third provision and it is about if MP or MLA becomes Speaker, Deputy Speaker, or MLC become Chairman, Deputy Chairman, and they resign from their political party, so they will not be disqualified from being the member of the House. These kind of 3 provisos exist under Anti-Defection Law. So these are basic provisions which exist under the Indian Constitution for defection, disqualification and exemption. Then what are the problems we are observing? We still have so many provisions of this anti-defection law, and despite that we have received the defections and collapse of the government in recent times at state level. So there are, next portion is about limitation. When we talk about limitations or criticisms, we will observe that, see, who can take decision? Speaker or chairman are supposed to take decision. But it has been observed these people also belong to political party and neutrality is under question. Because number of times it's possible they may get biased towards their own political party, and that's why it become a criticism for anti-defection law. Plus, who has to take decision in what time? So there is no time limit upon decision-making authority. That's a criteria. No time limit upon the decision-making authority. So sometimes it take 2 months, sometimes it take 2 years, and no such decisions are taken. Plus, the act is ineffective in case of regional or smaller parties. Just imagine a political party may have just 3 MPs and 2 are leaving the party. So they can easily satisfy the conditions of 2/3 and no person is going to be disqualified in those cases. Or if you do the mass defection, that example of the Maharashtra was also a kind of disqualification was violated because mass defection has been done by the members of political party. That's why it become ineffective in case of regional or smaller political party. Plus, if somebody is disqualified, MP, MLA or MLC, disqualified under anti-defection law, but they are eligible to contest elections, eligible to contest by elections, and they can become the member of the house again. They are eligible to become the member and eligible to become the member of the house again because they can contest this by elections. And also, it has also been observed that it does not cover coalition politics. Like in state of Maharashtra, there was earlier NDA government, it became Mahavikas Aghadi government, again it became NDA government, and this is during 2020 to 25, 3 years that change has taken place. Plus in the states like Bihar, there was also NDA government, NDA became Mahagathbandhan, and again it became NDA government, and that also has straightforward violated the provisions because there is no criteria to control the coalition partner, and this become a violation of anti-defection law. Therefore, to make it more effective, we can give a suggestion for reforms. So let's understand what are these suggestions for reform. They should be in accordance with the problems we are highlighting. So to overcome these problems, we can suggest reforms. One of them is second ARC. It suggested the decision for disqualification to be taken by president or governor. Instead, it is to be taken by the political representative. It can be taken by the constitutional head at the center and state level. That's why the second ARC suggested decision to be taken by them. Same second ARC also suggested there should be time limit upon decision-making authority. Whosoever has to take the decision, you must take a decision in a span of 3 months so that within adequate time period, we can control the political instability and maintain political stability and the process of governance. That's why these two suggestions are from the second ARC. Plus, we can also suggest that anti-defection law shall be amended to cover coalition politics. As a result, pre-poll alliance and post-poll alliance should be covered. That means we have become a coalition partner to contest the election, and people have voted in favor of our alliance. And after election, now we are fighting who will be the chief minister, and one of the coalition partner is withdrawing the support. This is like deceit to the voter, and therefore anti-defection law shall control the coalition politics, specifically when you are contesting election together as a pre-poll alliance, and also after the election you can continue with your same alliance. If you changes these alliance, it should attract the provisions under anti-defection law. Plus, we can even suggest here as a suggestion that the disqualified MP, MLA or MLC, those members who are disqualified under anti-defection law, they shall not be allowed to contest by elections. So that if they are changing their political party, they should not have an opportunity to become the member of the house at least for the next 5 years, because they change the political stand and then they move to another political party, and that results into political instability. So if they are not eligible to contest these by-election, then the benefit of moving to another party in the exchange of money or the position of a minister will be reduced to the minimum. And that's why this kind of logic we can carry for bringing effective reforms. And one more suggestion we can also bring, and it is like those people who are independent independent MP or independent MLCs, they shall be disqualified whenever they join political party. Because they are nominated on the basis of their experience in literature, art, science, and their decision should always be in the larger interest of the society, because when they become member of a party, they will be abide by their party whip and they will not be able to express freely their opinion. And for that purpose, this is an idea to suggest in such way. And one more suggestion we can also suggest, and it is to overcome the problem of regional and the smaller party, there shall be two set of provisions. One for the national parties and another for the regional parties. Because we have the concept of recognition of political parties as national parties and state parties by the Election Commission, and accordingly they are given the sequences also in the voter ID. And this is not about discrimination between the political party, but in fact it is about the concept of substantive equality among the political party. And these kind of suggestions we can use in order to improve the quality of an answer and make it a complete answer from the mains point of view. That is all. I hope we have understood this anti-defection law and have dealt with all the dimensions related to this portion from the prelims as well as mains point of view. Till then, keep on studying. We will meet again. Bye-bye. Thank you.